Yeah, I have an idea that builds upon what Andrew's doing, but this might actually be a good question for you because it encompasses what you're already discussing, but brings in another example. I was explaining this to my father, who's an attorney as well, as I mentioned, and he understood what I was getting at because in the Darren Wilson case, you had two local prosecutors, you had the federal DOJ, all say that it was 100% clean shoot. Since then, they've elected two new district attorneys, both of which, in order to get elected, had promised that if they're put in office, they will prosecute Darren Wilson. So you now have a situation where the people want someone's head on a pike and they're going to elect whoever says they're going to do it. And Darren Wilson has to sit there and wonder if one day they're going to get somebody in office who's going to prosecute him unjustly.
Well, they keep doing that. They keep electing new prosecutors who run for the office on, as you say, on the talking point that they'll reopen the Michael Brown, Darren Wilson case. And they get in office, they get elected because generally they have George Soros money behind them. So they bring $500,000 to a prosecutor's race that normally might involve $5,000. So they just buy the seat essentially. But all of them, when they reopen the case, they look at the facts and then they close it again a few weeks later because there is no legal merit there. So I don't really see anything happening there. But the Darren Wilson case is a very good illustrative example. So that prosecutor who was involved in that case, he'd been the prosecutor in that jurisdiction forever. For I think it was 30 years, maybe more. And when he brought that case to the grand jury, he did something he was not obliged to do. He told the grand jury both sides of the story, not just the prosecution side, but the defense side as well. And when the grand jury heard both sides of the story, they returned a no true bill. There was no indictment. There was no trial as a result. That guy got targeted by Soros-funded sources, and he got replaced by a young prosecutor running on the campaign talking point of reopening the Darren Wilson case. So that prosecutor who'd been in that office for decades, he did the right thing. And the consequence for him was he lost his job. He lost his career and a new person took over. So that's a lesson to every other prosecutor out there. You can do the right thing if you want, but don't expect to keep your job afterwards. And now we have this prosecutor down in Georgia around the Ahmaud Arbery case who had recused herself from the case, and now she's facing felony charges of failure to do her duty because she simply decided she didn't stop the case from happening. She just said, I'm not the right person to prosecute this case. So it was handed to a different prosecutor. Obviously, the trial was still pursued. Nothing was stopped. And she's looking at a felony conviction now. And even if they don't get that, it's a lesson to every other prosecutor out there. You better bend the knee to the mob, or at the very least, you'll lose your job and maybe we'll put you in jail.
Yeah, I think grand jury reform is something that needs to be part of this as well. Because as you mentioned, the Dershowitz quote, you can indict a ham sandwich. You can with a grand jury. And that's the big issue. If the defense had some rights in submitting a case to a grand jury, then a lot of these situations would never come to fruition, just like in the example you provided.
And often, in many jurisdictions, they don't have to go to a grand jury. I mean, in the George Zimmerman case, for example, they use what's called an information, which is a sworn document, usually sworn by a law enforcement officer, like a criminal complaint, attesting to certain facts in the case. And I see this over and over again, where you look at the criminal complaint or you look at the information, and there'll always be something extravagant in there to act as an accelerant, gasoline on the fire, to compel a prosecution. In the George Zimmerman case, it was that he racially profiled Trayvon Martin. Well, that sounds horrible, but they needed something to justify a second-degree malice murder charge, which is what they brought against him. So where was the malice? It was the racial profiling. Except when they actually get to trial, you never hear a word about racial profiling because there's no evidence of racial profiling. And once you get to court, you start making claims, they have to be backed up by actual evidence. So they made this up to put in the criminal complaint, to drag him into trial. And then when they get to trial, the claim doesn't exist anymore. And that's horrible and should not be permitted. And it happens in many of these cases. You look at the criminal complaint, same thing. You look at the criminal complaint, they're making claims in there that in hindsight will prove to have been completely fabricated, and no one is ever held accountable for that. It's like if you went to the doctor with a sniffle and the doctor said, you know what? There's like a 1 in a million chance you actually have cancer. So we're going to start you on chemotherapy and radiation right now because you came in with a sniffle. There need to be checks in between those two extremes before you're subject to that kind of therapy. And that should apply in the same context as a criminal trial as well.